Greetings and salutations, all my fellow American sovereigns. This is the Vocational Science of Freedom Saturday Night Civics and Sovereignty class, and tonight will be the sixth reading of the website USA versus US. And in the show notes, if you're listening to this later, I'll have the layout of the vocabulary words that we'll cover tonight, because I found in this site that some of the things that he puts on either side, and the right-hand side is the de facto side, and the left-hand side is the de jure. De jure meaning by right, and de facto meaning by fact, meaning it's there, but it's not legitimate. Some of these definitions and some of these ideas that he has in here are not exactly correct. And I never want to give anybody any information that's not 100% correct. So I put together a vocabulary list for tonight, and in it, I'll be going over each of the vocabulary words that I feel he either might have not gotten correct, meaning he put them on the wrong side, or he might have not even really known what these things mean. So all the definitions in the vocabulary list are going to come from Bouvier's Law Dictionary, 1856 edition. And we'll go over them, not exhaustively, but I just wanted to make sure that I gave them to everyone so that you guys can double check them and read them over at your own volition. Okay, so I haven't really talked about any of the little links on the sides of this website. I know some of the links are broken also. I don't know how often he updates this website, but on the left-hand side, I did notice this aspect of the CAFRs. And CAFR stands for Comprehensive Annual Financial Report. And a lot of people don't understand that the corporate government has basically kind of what he mentions, like two sets of books. And the Comprehensive Annual Financial Reports are the bookkeeping of basically what the corporation is doing. So you have CAFRs for cities, municipalities. You have CAFRs for counties. And all these municipalities, all these corporations that are pretending to be government, they all have their own Dun & Bradstreet numbers as well, which you can look up on dnb.com. And I don't recall if you still have to set up an account with DNB to actually see them any longer. But anyway, they're there. And for every county, you'll see for the Dun & Bradstreet number, it'll usually say, now not always, but it'll usually say the district attorney for each county when you look up their Dun & Bradstreet information. So say the district attorney for Clarence County is John Henry Doe, right? So you go look up the Dun & Bradstreet information for John Henry Doe, and a lot of the times it will say also traded as such and such county. And that's your first clue that you're being run by corporate government. Your second and possibly biggest clue is the fact that the Dun & Bradstreet numbers are connected to the CAFRs. And there's a link here which says more info. And I'll just briefly go through this because I've never really talked about the CAFRs at all. I do want to eventually do a class on it, but it's not something that I focus on because aside from proving the fact that we have corporate government, there really isn't anything to be, say, done with them, meaning there's no real use for them as far as, say, putting the information into a court case or whatever else. It just proves the fraud of what they're doing. So the biggest shell game for theft in this world's history. Government at all levels holds back its annual financial report from the people of America for over 50 years. By Walter J. Burren. Every city, county, state, and the federal government openly talks about the quote-unquote budget, but keeps a virtually hidden second set of books, which track the investments and enterprise ventures worth trillions of dollars, intangible wealth they have built up and are spending from these virtual hidden portfolios as a result of investing your skimmed money for over 50 years in everything from real estate to stock market. And so motive, they build their empires from where that money is spent and invested internationally. When looking at the big picture, only 1/3 of government's annual revenue comes from taxes. 2/3 comes from return on investments and enterprise venture projects. To offset taxation, not $1 of that non-tax revenue is tied directly to the annual quote-unquote budget that is supported by taxation. Your city, county, state, and federal governments have lied to you for decades. With administrative reconstructuring of government, there is no need for taxes. Our governments are not broke. They are rich beyond measure with our money. Now, I would pause and make a point that the United States Federal Corporation is definitely, quote-unquote, bankrupt. However, I will agree with them. They're not broke. And they are hiding it from the American taxpayer, investing and spending it while pleading they are broke and need more taxes, bonds, and levies to survive. This being done as they blindly justify their obscene growth. There is enough aggregate wealth owned by our corporate government agencies to abolish all property and income taxes today. You are being conned, lied to, ripped off, and financially raped. Total annual personal income of USA, this is quite a few years ago, 24 to be precise, was $8.2 trillion. All income, wages, and investment returned from Bill Gates' government employees to the local paperboy. Federal income tax, $1.8 trillion. Local government tax, $1.6 trillion. Total disclosed government general purpose tax income, $3.4 trillion. Personal income, now this would be the CAFRs that he's speaking of, 8.2 to 3.4 taxation equals $4.8 trillion. The net personal income after all taxation from both federal and local governments. And source, 1999 Combined Financial Statements, CFS. Now for the revelation. Estimated investment enterprise income not disclosed in the general fund accounting, both federal and local government, would bring federal and local government's annual total income up by another $5.1 trillion. Government's non-tax income, or total income of $8.5 trillion, or for the real earthshaker of the mind's comprehension, government income twice that of the total annual net personal income after taxation of the entire nation. So I'll just leave it at that. And another thing that I want to mention about the CAFRs, and you guys are welcome to read the rest of this just off the link that's in USA versus US here. It's just right here where it says more info. But another thing about the CAFRs I just want to mention is that some men have spent their entire lives researching and exposing the whole entire CAFR fraud, if you will. And there was another website, and I tried to look for it, and I don't think I have it bookmarked. I don't even know if it's up anymore. But there was another gentleman, and I think it might have been the same gentleman that was writing that article. And he spent years, 50 years, and I know he wrote a few books as well on the subject. So what the CAFRs are is it's basically showing how many stocks and investments and everything else that the municipalities and the corporate state own, what their returns are, and so on and so forth. So this whole entire corporate government, in a very strange sense, owns the majority of all of the stock of all of the corporations in America. So you want to talk about a 100% fascist state, and fascism being the definition of government and corporations basically merging together, just that very simple definition. I don't want to get into the politics of it. But on that very basic definition, there's no question that the United States is already 100% and has been basically since 1933 completely fascist. And that they don't tell us any of this. And they keep saying, oh, you owe that, you owe this, you owe that, is a pretty big fraud. And that's the reason, one of the many reasons, why I created the Vocational Science of Freedom status stocks, to get you out of the situation of having to pay taxes and being subject to their jurisdiction by contracts, trusts, pledges, bonds, oaths, all of it. Because there's no reason to be a part of a corporation that only wishes to do you harm. So, and then below this, it says, if the corporate government says they can't meet the budget or need to cut back services, they are not telling you the whole truth, and that's so they can get more money from you. Okay, so that's just a little side thing about the CAFRs. All right, so to get into the meat of where we left off, last time we left off at suit and action here, and I'm going to bring up the vocabulary list here so that everybody can actually see what these are. Now, I'm not going to go through the vocabulary list exhaustively today. I just want to mention that it'll be in the show notes in the mega file to be able to download for later so that you can go through these definitions and actually read what they actually say. So first off, we have suit. And remember, the left side here is the de jure, right side's the de facto. So he's saying that suit is de jure and action is de facto. Well, that's simply not the truth. A suit is an action. The word suit in the 25th section of the Judiciary Act of 1789 applies to any proceeding in a court of justice in which the plaintiff pursues, in such court, the remedy which the law affords him. An application for a prohibition is therefore a suit. Number two, in its most extended sense, the word suit includes not only a civil action, but also criminal prosecution as indictment, which would be from a grand jury, information, which we'll get to later, and a conviction by a magistrate. Okay, so that's a suit. Okay, so what's an action? Well, the word action was in the definition of suit. But anyway, action in practice, and I'm not going to bother to read that Latin because I'd probably butcher it. So action in practice. Actions are divided into criminal and civil. A criminal action is a prosecution in a court of justice in the name of the government against one or more individuals accused of a crime. Civil action is a legal demand of one's rights, or it is the form given by law for the recovery of that which is due. Till judgment, I'm kind of skipping through the law here. Okay, so, all right, till judgment, the writ is properly called an action. Okay, so when you file an original writ, which is how most common law suits regularly started, you would file an original writ, and within the writ, you'd have what was called a declaration. And there's 7 parts to a declaration, and there's 9 parts to a bill, meaning a bill in equity. And I'm not going to go through all those tonight. Those are explained in other classes, so I'm not going to rehash that. But just to understand what these things are at common law versus everything on the right-hand side, being equity, maritime amity, ecclesiastical, military, and so forth, it's important that you don't confuse these things. Okay, so a writ is properly called an action, but not after, and therefore a release of all action is regularly no bar of all execution. They are, meaning actions, they are real, personal, and mixed. An action is real or personal according as reality or personality is recovered, not according to the nature of the defense. And to simplify this a little bit better, so a real action is that which is something that's going after property. A personal action is that which is going after somebody else, meaning like they trespassed upon you or whatnot, or you want damages or something. And then a mixed action is usually what you have in dealing with matters of land rights under the common law. But again, that's, if you guys want to really understand a lot more regarding what these actions are and what suits are, and a lot of what we're covering tonight, I highly suggest that everybody watch the Vocational Science of Freedom class on the totality of law class and the ins and outs of court together. These two will explain a lot of these concepts in far more detail than I'm going to even attempt to go over tonight. Okay. So if you want to deep dive into that, these are the 2 classes that I would suggest that everybody watch. And they're on all the platforms as well. So they're on Rumble and they're also on Odyssey. These are just where they're at on the YouTube page. So just go to playlists and then click on them. Okay, so anyway, back to this. So that's an action. I'm not going to read all of these different types of actions. Again, I just kind of generally stated what they are. So you have real action, personal action, mixed action. and personal actions of different kinds, and so on and so forth. Okay, so that's that. All right. The next crime, a noun, injury to a man, woman, or child, or damage to their party, must be an injured party, must show actual harm or damage. Okay, fine. That's one way to state it, but that's also, under the common law, defined as a tort. So is that really the correct definition of a crime? No. And on the other side, the de facto side, it states criminal offense. Criminal is an adjective, not a noun. An offense is not a crime, but a violation of policy. And of course, he means public policy. Enforcement of policies. The name police came from policies. Actually, it didn't. It came from the word polis, but anyway. So that's even not necessarily correct either. Okay. Accuser, at least this one, Bouvier's had a definition for, is just one who makes an accusation. And that's, he says, is on the Dejure side. So on the de facto side, plaintiff, informant, complainant. Plaintiff, practice, he who, in a personal action, seeks a remedy for an injury to his rights. That's fine. There's no problem with that. There's no aspect of that being de facto, the use of the term plaintiff. It simply isn't. And then plaintiffs are legal or equitable. The legal plaintiff is he in whom the legal title or cause of action is vested. The equitable plaintiff is he who, not having legal title, yet is in equity entitled to the thing sued for, or sometimes for the monetary damages of it, or even the use of it. For example, when a suit is brought by Benjamin Franklin for the use of Robert Morris, Benjamin Franklin is the legal and Robert Morris is the equitable plaintiff. This is the usual manner of bringing suit when the cause of action is not assignable at law, meaning under common law, but is so in equity. So in that sense, okay, is the definition sort of hinting towards the idea that the word plaintiff is only something on the equitable side? Yeah, maybe. If you use the word plaintiff in, say, the heading, meaning your court heading, when you filed a suit, it wouldn't change the fact if you were at law or equity, meaning the use of the word plaintiff would not automatically put you into some equity court. What determines what court you're in is stated within the body of the action or the writ, the original writ. Okay. Okay. And then accused, no defense attorney. So he's saying accused is on the Dejure side. No defense necessary unless evidence and witnesses is overwhelming. Well, no. If someone brings a suit against you, they can do it in a lot of different ways. They can do it in a lot of different jurisdictions. So it's not automatically that they are on the Dejure side. Simply not the case. And then he's saying on the de facto side, it's named the defendant needs to defend against guilt assumption. Well, yeah, you need to defend against whatever's going on. However, that's not automatically what that means. Meaning you don't have to be called a defendant to be in a situation to do that. Okay, so this is composed by Ed Rivera. Okay, that's a guy who I have learned a lot from and trust his info. Okay, free law information in the legal system is privately owned. True. All courts in the United States are privately owned by the Crown Temple in London. I've never seen proof of that. I know they're owned and through the Kaffers. I know that they have their own Dun & Bradstreet numbers, but I've never been able to find any evidence that they're all linked back to the Inner Temple and Middle Temple in London. Wouldn't surprise me. I'm not saying it's a invalid theory. I would, however, like to see proof of that at some point. Number 2, all attorneys and judges are agents of the privately owned Crown Temple. Pretty much true. All United States courts are admiralty courts under color of law. It appears to be law, but is not. Well, again, this gets to the fact that they're running all the jurisdictions at the same time when you wander into these inferior courts. So it's not just admiralty law that they're dealing with. 4, all defendants are wards of the court. That's true for various different reasons, which I've already spoken of during the rest of the reading of this particular series, so I'm not going to rehash that. All attorneys are attornors or twisters. That's funny, but true. To attorn means to take from one and give to another. That's literally where the definition of attorney comes from and the etymology. 6, all attorneys and judges are officers of the court, a conflict of interest. Well, yes, no, because they don't actually work for the state. If they did actually work for the state, meaning that these courts didn't have separate purses from the state, and the state was, quote unquote, the plaintiff or the accuser, then that would be a conflict of interest. But because they're all private for-profit courts, there's no conflict of interest because the officers thereof aren't the plaintiffs. They are separate. So, 7, admiralty jurisdiction means the judge has the power of an admiral on a ship. Well, more like a captain, but yeah, sure. 8, admiral on a ship has absolute power over life and death. True. 9, defendants have no rights in court. Yeah, for a lot of the inferior jurisdictions, I would agree with that. 10, all statutes in the United States only apply to persons who are fictitious entities. Well, they apply to infants. That's what a person is. It's an infant. I wish people would stop getting this wrong. I mean, for God's sakes, how many times do I have to say it? But anyway, a person is not necessarily a fictitious entity. Yes, it can be, but this is the definition of person under the United States Code, people. 1, USC, subsection 8, person, human being, child, and individual, as including, born alive, infant. In determining the meaning of any act of Congress or of any ruling, regulation, or interpretation of the various administrative bureaus and agencies of the United States, the words person, human being, child, and individual shall include every infant member of the species Homo sapiens who is born alive at any stage of development. A person is an infant. End of discussion. So, 11. United States courts have no jurisdiction over a man or woman, only artificial persons. United States courts have jurisdiction over their 14th Amendment citizen slaves and infants because the infants have not come back and claimed their estate. All they're doing is administering abandoned infant estates. That's what they're doing. Yes, do they also have jurisdiction over artificial persons? Sure, like corporations and municipalities and all other shit. Are those things also considered persons? Yes, but that is the aspect of the corporate connection to them. You are not an artificial entity, nor do you have one. You have an estate, which they turn into constructive trusts, which are artificial entities. But the person itself is not some sort of artificial entity with, say, its own little corporate structure. All right. 12, most traffic tickets are infractions. True. And they're also being run through probate court, which we talked about last time. 13, you cannot be put in jail for an infraction. Well, I guess I would. No, well, that's true. One of the people cannot be put in jail for an infraction. That's true. Infants, yeah. If you have a contract with them, particularly like the driver's license, then you've agreed to be put in jail from them because you've agreed to adjudicate those matters in a nisi prius court. And for those of you who don't know what nisi prius means, nisi prius means a court of prior agreement. So if you entered into a contract with someone, say your neighbor, and in the contract it said that he was going to pay you to paint the house, you agree to paint the house, and if you don't paint the house, he gets to drag you before 12 of his buddies, which are named in the contract, out into a public park and they get to stone you. Okay, that sounds crazy, but that's contractual. Everything as you do contractually waives your fucking protected rights, both state and federal. Why is that? It's because both the state and federal constitutions both have clauses in them that state that there shall be no law passed abrogating the right of contract. That means you can contract your ass into whatever stupidity you find yourself. The point is, remove yourself from the contracts. All right, 14. You can plea bargain with the judge to cut down your fine against you. Yeah, sure. You can also do it with the district attorney. 15. You cannot be put in jail for an infraction. They have no way to collect the fine. Well, that's a good point. Jerome Daly case proves that Federal Reserve notes have no lawful consideration. And there's also the famous Peanut case dealing with mortgage foreclosure, where a man argued to the hilt that Federal Reserve notes had no lawful consideration. Finally got the judge so pissed off that he said, I don't care if you pay in peanuts. And the guy said, I accept your offer of contract. Right after the judge said that. And he literally came in the next day with like 80,000 peanuts. And that was contractual. They had to let him go. I mean, they had to let him keep the house and they had to take the damn peanuts. And yes, that's serious, because if you say something in court, or if the judge messes up in court and says something or doesn't say something, yeah, you can lock it down. Because remember, this is all contractual. 16. The judge will try to charge you with contempt or coerce you to pay the fine. That's true. And if those two things don't work, he'll threaten you with putting you in a insane asylum. 17. You cannot be lawfully charged with contempt unless you are disrespectful to the judge. You can also be charged with contempt if the infants don't follow the inferior court's orders. That's another way to do it too. And that's not just being disrespectful to the judge. 18, you cannot pay the fine. They have to let you go because you cannot be put in jail. That's true. That's an aspect of no debt prisons. So that's true. 19, they may summons you back to court again to pay the fine. Again, sure, fine. Again, just infants. Since they cannot put you in jail and you obey all summons, they will give you up because they want the money and you are wasting the court's time. Well, sometimes. It depends how much and how badly you've pissed them off, really. Because all of these inferior courts are just about control. That's all they are. Just forcing you to obey. Be good little infants. 21. Search Yahoo or Google under Crown Temple to see who owns you and your property. Well, that, goes back to the city of London. 22. Under Admiralty law, you cannot have a fully informed jury. I don't agree with that one. That would have to be proved, because I can't think off the top of my head any place where that is ever stated. Nor does it even make any sense. Anyway, 23, common law is the law of the people. True. 24, that's just Ed Rivera's site. Good site, though. 25, Admiralty law is the king, is the law of the king or sovereign. True. Well, as is all law that's decreed by a king or sovereign. So that's kind of a misnomer. 26, most Americans are no longer sovereigns. They are subject slaves. Incorrect. You can't lose your sovereignty, but you can certainly waive it. Or fail to claim it. Let's put it that way. Because if you never claim your estate, you can never be part of the posterity spoken of in both the state and federal constitutions. Therefore, you can't be seen as a fellow member of the peerage because you haven't claimed your title. So that's how that works. 27, all courts in America are territorial courts under congressional jurisdiction. I would say that's probably true in some cases. I don't think it's true in all of them, because the rest of them are just private for-profit corporations doing their thing. Okay, so anyway, interesting little side check there and that was under the de facto side, under more information, under defendant. Okay, accusation. Back to the Dejure side here. Accusation, claim. Other terms used, true bill, libel, or injury. Okay, well, all right. So information, complaint. Do I have accusation here? Okay, I do. All right, accusation, criminal law. A charge made to a competent officer, meaning a magistrate or cop or judge, whoever, against one who has committed a crime or misdemeanor so that he may be brought to justice and punishment. Definition 2, a neglect to accuse may in some cases be considered a misdemeanor or misprison. That's true, and also an interesting aspect of that is what's called misprison of felony. So if you know that someone's committed a felony, and this aspect works both at common law and in equity and under the United States Code as well. So misprison of felony, if you know someone committed a felony and then you fail to report it, then you can be charged as well, which, of course, that happens every single day in Washington, D.C., without question, but nobody ever comes down on them for misprison of felony. Because once that card at the bottom of the house of cards got pulled, oh, the rest of them would fall pretty quickly because you could just wrap them all up with just that single use of that single statute. Or I should say U.S. code, but anyway. All right, number 3, meaning definition of accusation. Number 3, it is a rule that no man is bound to accuse himself or to testify against himself in a criminal case. True. That's Fifth Amendment. Okay, and then the next is claim. A claim is a challenge of ownership of a thing which a man has not in his possession and is wrongfully withheld by another. Now he's saying on the website, claim is other terms used to true bill or libel. Well, no. A true bill is something in equity. A declaration is something at law. And then a libel is just a form of action, which you can do at law or in equity. So injury is a wrong or a tort, and injuries are divided into public and private, and they affect the person, personal property, or real property. And the difference between personal property and real property, if nobody knows, real property is the land. Personal property is your motorcycle. And then next definition under injury, they affect the person absolutely or relatively. The absolute injuries are threats and menaces, assaults, batteries, wounding, mayhems, injuries to health by nuisances or medical malpractice, and then period. Those affecting reputation are verbal slander, libels, which is written, and malicious prosecutions. And those affecting personal liberty are false imprisonment and malicious prosecutions. The relative injuries are those which affect the rights of a husband. Those are abduction of the wife or harboring her, adultery and battery, which those affect the rights of a parent as abduction, seduction, or battery of a child, and then semicolon, and of master, meaning your master. This one really doesn't apply anymore, but it's not just master slave. That's not what that means. It means when you used to have apprentices and masters, this is kind of what this is getting at. And of master, seduction, harboring, and battery of his apprentice or servant, period. Those which conflict with the rights of the inferior relation, namely the wife, child, apprentice, or servant, are withholding conjugal rights, maintenance, and wages. Meaning that that's something that the inferior relation of those stated can sue as an injury against the superior. So, hey, you're not letting me have my rights. Hey, you're not paying me, whatever you said you're going to pay me, so on and so forth. All right, so next definition of injury. Okay, injuries to personal property are the unlawful taking and detention thereof from the owner. So he took someone's dog and didn't give it back. And other injuries are some damage affecting the same, meaning you beat the dog up or whatever, while in the claimant's possession, or that of a third person, or injuries to his revisionary interests. And the revisionary interest let's say a cow instead of a dog, because then it makes more sense. Okay, or even a horse, that's even better. Okay, so a revisionary interest, so somebody stole your horse, you sue them for the horse and for the loss of income that you suffered during the time that he had the horse because you couldn't plow your field, right? That's kind of what that's about. And then next one, injuries to real property. And this again, real property is dealing with the land. So ousters, which I won't get into, trespasses, everybody knows what that is, nuisances, waste, subtraction of rent, disturbance of right of way, and the like. And then injuries arrive in 3 ways: by nonfeasance, or that not doing what is legal obligation. Basically, you didn't fulfill a contract or duty or contract to perform. And then misfeasance, or the performance in an improper manner. Say you painted the house, but you painted it green instead of blue, of an act which was either the party's duty or his contract to perform. Malfeasance, or the unjust performance of some act which the party had no right, meaning you came and painted the house, but you decided to steal the gutters, or which he had not contracted not to do. And then there's private right and individual right regarding injuries, which I won't get into because injuries go on for a while here, like quite a while in the definition. So anyway, so all of that was just injury, wrong or tort. So that's injury on the common law side. So injury civil law is the other side of it. In a technical sense, no, hold on. That doesn't make sense because some of these were referring. Oh, that's right. You can take care of contractual matters at law. Never mind. Okay, so injury civil law. In the technical sense of the term, it is a delicit committed in contempt or outrage of anyone, whereby his body, his dignity, or his reputation is maliciously injured. Injuries may be divided into two classes with reference to the means used by the wrongdoer, namely by words or by acts, and the first are called verbal injuries, the latter real. A verbal injury when directed against a private person consists of uttering tumultuous words which tend to expose his character by making him little or ridiculous, funny. Where the offensive words are uttered in the heat of a dispute and spoken to the person's face, the law does not presume any malicious intention to the utterer, whose resentment generally subsides with his passion. Well, maybe. Not always. And yet, even in that case, the truth of the injurious word seldom absolves entirely from punishment. To talk about a verbal injury is kind of ridiculous because it's kind of getting into, oh, you hurt my feelings. I'm a left-wing communist. You're wearing a MAGA hat. That hurts me. Ouch. Right. Well, okay. The verbal injury thing, really what it really comes down to are aspects of like threats or stating something that destroys a person's character in, say, a very public setting. Those are things that, yeah, someone could sue for, right? But it's not like, oh, I feel so horrible because you're wearing a MAGA hat. No, I'm sorry. Doesn't work. Okay, so anyway. All right, so that's injury. I'll just stop at that. Okay, so the next thing over here. All right, so charge. So he has, on the Dejure side, accusation, claim, injury, and on the Defacto side, he has charge. Well, okay, let's check this out and see if this fits here. Charge, practice. The opinion expressed by the court to the jury on the law arising out of a case before him. Okay, so I don't see anything there regarding equity or inferior courts necessarily. And then second definition, it should contain a clear and explicit exposition of the law when the points of the law in dispute arise out of the facts proved on the trial of the cause. That's just determining if the law applies, basically, which is up to the jury if it's in a court of record and you've demanded a general verdict. Okay, to continue. But the court ought at no time to undertake to decide the facts, for those are to be decided by the jury. True. Okay, so that's just the definition of charge. There's nothing there that says it's de facto, nor is there anything there that even says that it's necessarily automatically an aspect of admiralty, equity, maritime, any of it. Anything that would be an inferior court to a court of record. So, yeah. All right, next one, writ. Writ, practice, a mandatory precept issued by the authority and in the name of the sovereign of the state, which, by the way, is you, if you happen to issue an original writ. And there's all kinds of different kinds of writs. I won't get into them, but like a writ that we would do would be an absolute judicial extraordinary prerogative writ of, say, mandamus or habeas corpus or quo warranto, right? Because they're coming from the sovereign. They're absolute, they're judicial, because that's just basically what writs are. And they're prerogative because, well, we feel like it. Okay, so a writ, again, a mandatory precept issued by the authority, you, and in the name of the sovereign of the state, which can be done by an attorney general as long as they write it that way, that this is done in the name of the people of the state of Alabama. Okay, that's fine. But that's why they have to write it like that, by the way. For the purpose of compelling the defendant to do something therein mentioned. 2, it is issued by a court or other competent jurisdiction. Again, other competent jurisdiction is you. And is returnable to the same, meaning give it to the sheriff, they go serve it, it gets returned back to you and a copy to the court. It is to be under seal and tested, meaning that's properly pronounced tested, by the proper officer. So what seal? What seal should it be under? Your house seal? Yeah. And then if you want it also sealed by the court that you're running it through, that's fine too. But technically, the seal of your superior court is your house seal. And if you don't have one, get your status docs done. I explain how to do that. Okay, and then and is directed to the sheriff and or other officer lawfully authorized to execute the same, which is coroner, and in some certain situations, marshals or your own judicial coroner or your own special masters can also do it. Okay, so then types of writs are original of min's process or min's process. That means middle process, which isn't really something that's really done anymore. And that gets into the whole aspect of common law procedure, which I don't want to open up right now. And then 3 of execution. So you have a writ of execution is like the final thing. It's like the final decision from the court. It's all signed. It's sealed by you. Everybody knows what happened. Go get your horse, sort of thing. Okay. And then there are several kinds of writs, some of which are mentioned below, which I just cut all out because writs in Bouvier's Law Dictionary go on for a long time. So I didn't want to overly burden you guys with all those different types of writs. But they are interesting. And if you want to read all of them from Bouvier's Law Dictionary, feel free to join the Vocational Science of Freedom by simply going to vocationalscienceoffreedom.org, download the welcome package, get on the Revolt server, and then you can find the mega link for the reference section of the Vocational Science of Freedom members online library, which has not only all of Bouvier's, but all of Black's and a lot of other reference material free to download. Okay, so let's see what this side says on the website here for the Dejure. So writ, form of written command in the name of one in authority, such as a sovereign, such as a member of we the people. True, that's what I said. Some examples are as follows: writ of habeas corpus, writ of mandamus, writ of prohibition, writ of cert, which is just, it's certiorari, but it's always shortened to cert. Order demanding the record, which is also what you put into the Supreme Court. Even though they call it a petition for cert, they don't really call it a writ anymore. But anyway, I was kind of be interested in what would happen if somebody did properly file an original writ of certiorari to the Supreme Court. I always wondered if they had to move that up and take that first. But anyway, and then it says, although most definitions today only mentions that writs can be issued by a judge or are a court order, in reality, almost anyone, except U.S. citizens, can issue such writs. Writs are tools of the common law. That's true. I fully agree with that. Okay, so that's writ on the de jure side. Now he's saying motion is de facto, but he's saying this. So on the website, it says a formal application to a court, so-called judge, for its order, ruling, judgment, or decree. That's Ballantyne's. Okay, fine. And then a motion must be supported by an affidavit, but the affidavit cannot be read during the hearing. Okay, so what does Bouvier say? So motion practice, an application to a court by one of the parties in a cause. Okay. Or his counsel. Okay. Doesn't say attorney, says counsel. In order to obtain some rule or order of court, which he thinks becomes necessary in the progress of the cause, or to get relieved in a summary manner from some manner which would work injustice. That's true. All a motion is just asking the court to do something. You move the court to do whatever. You give them reasons why they should do whatever. You give them law to explain why they should do whatever. You give them court holdings to explain that, hey, 1,000 judges before you did this, whatever. That's it. You're just moving the court, because the court is a dead thing. It just sits there. The judge is not the court. The court is the record, basically. But you have to move the court to do something. And yes, even if you're the plaintiff in a court of record, you still move your own court. Perfectly fine. So, anyway, definition 2. When the motion is made on some matter of fact, it must be supported by an affidavit that such facts are true, and for this purpose, the party's affidavit will be received, though it cannot be read on the hearing. Oh, okay. So even, well, that's odd. So Bouvier says that as well. It cannot be read on the hearing. Huh. So they do both say that. That's odd because I know men that have done that. Well, maybe they weren't supposed to. Anyway. Okay, so that's motion. So again, there's nothing here regarding a motion that's automatically de facto. Sorry. Not true. All right. Dejure side emits writs of error, presents oneself, and then venue, and then in law. Okay, so Dejure emits writs, submits documents. Well, yeah, more like files things into an inferior court that they never look at. That's pretty much the submission. And then a writ of error on the de jure side, and then appeal on the de facto, or so he says. So what does Bouvier say about appeal? Appeal practice. The act by which a party submits to the decision of a superior court a cause which has been tried in an inferior tribunal. Okay. So that's just an inferior and superior aspect of, say, you had something at a municipal court and then you appeal it to the state district court or the state Supreme Court. Fine. Now, is that automatically some aspect of equity or some aspect of Roman civil law? Kind of, sort of. I mean, I would say that one probably has certainly the look and feel of the other side, because a writ of error is definitely only a de jure thing that you do on that side. Because in a writ of error, you're actually stating that the court itself made an error because they did X, Y, Z. Basically, with a writ of error, what you're basically doing is suing the court to fix the error, okay? Which is definitely something entirely different than an appeal. Okay, so then to continue over here with Bouvier's. So definition 2, the appeal generally annuls the judgment of the inferior court so far that no action can be taken upon it until after the final decision of the cause. Its object is to review the whole case and to secure a just judgment upon the merits. 3, an appeal differs from proceedings in error, which is the writ of error, which is what I just said, under which the errors committed in the proceedings are examined, and if any have been committed, the first judgment is reversed. True. Because in the appeal, the whole case is examined and tried as if it had not been tried before. Now, that's an interesting way to put that. Yeah, because appellate courts have the capacity to fix, alter, reverse anything that the inferior court did. So yeah, okay, that's true. I get that. All right, so that's appeal. So again, is there anything absolutely there? Okay, aside from the fact that I'll say this, you cannot appeal anything from a court of record that was done correctly by jury trial. That I will completely agree with, because that's stated in the federal Constitution, clearly. So, and that's also the aspect of double jeopardy. So once a de jure court of record and a jury thereof decides both the facts and law in the case, then that's it. It's a done deal. Okay, so venue. Venue is a place, the county of which the jury are to come, who are to try the issue. Okay. So Bouvier says the venue is the county from which the jury are to come. Okay, so literally same thing. Number 2, as it is a general rule that the place of every traversable fact stated in the pleadings must be distinctively alleged, or that some certain place must be alleged for every such fact, it follows that a venue must be stated in every declaration. And again, a declaration is part of the original writ and part of the action that goes with it. And that makes sense, because you have to say, hey, so-and-so broke such and such law. Well, where did he do it? In Germany? I mean, you have to state the venue. 3, in local actions in which the subject of a thing to be recovered is local, meaning the horse at your neighbor's house, the true venue must be laid. True. Because you can't invoke a jurisdiction in another location without stating it in the original action. Among those are real actions and actions which arise out of some local subject, the violation of some local rights or interest, as the common law action of waste, trespass for nuisance to houses and lands, disturbance of right of way, obstruction or division of ancient water courses, so on and so forth. 4. In a transitory action, the plaintiff may lay the venue in any county he pleases. Okay. All right. So what the hell is transitory action? That's something like, hey, the guy stole my semi-truck, but he might be 3 states away. That becomes a transitory action because the thing that he took is on the move, basically. And then it says that he may bring suit wherever he may find the defendant and lay his cause of action to have arisen there, even though the cause of action originated in a foreign jurisdiction. Right. So he stole it in New York, but you found him in Arizona, whatever. You can initiate the suit in Arizona. Okay. Then what else we have down here? I'm just going to skip down. Okay. This one is kind of correct. On the Dejure side, he says, man, woman, child. One of the people, a living soul, flesh and blood. Okay. I will agree with one of the people. That, without question, I'll agree to that one. However, I don't tend to use man, woman, child in my documents. I'll say free man or free woman, but I won't just use the term man because there's a couple places in Roman civil law, I believe it's part of the U.S. Code, where it talks about man and other animals. And that was a case that a gentleman by the name of Alfred Addisk brought in Texas. And he said, hey, look, none of the U.S. Code applies to me because you define man as an animal. He's like, I'm not an animal. And that was a really big hubbub. I believe you can still find that case. I think I might even have it. But anyway, that's why I don't just use the word man. I'll say freeman because that has a different definition. But on the Dejure side, one of the people is a good and proper thing to say. I like to say, at least on paper, one of the people of the several states of the American Union. Because then you know you're talking about the Republic. You also know that you're talking about the people within that Republic who are automatically sovereign. So that's the way I like to say it. And then on de facto side, we have person. That one is definitely a no-no. Never call yourself a person. Defined as a corporation, trust, partnership, artificial legal entity. Wrong. It's defined as an infant. I just read that. Again, it's 1 USC, subsection 8, and I'll put it in the chat in case anybody out there wants to go look it up and verify it, because it's true. Not to mention I haven't harped on this enough times over the years, but nonetheless, it's always important to keep that one specifically saved. Okay. Oh, I just saw something in Mega Chat. Number said, how do you do number 21? Oh, were you referring to the list in the stuff? Which one was 21? Search Yahoo or Google under Temple Crown to see who owns you and your property. Oh, yeah. See, that one's so vague. I don't even exactly know what on earth he's talking about. And supposedly this is written by Ed Rivera or composed by Ed Rivera, but I don't know him to be that vague. But I don't know. And I don't even know exactly what he's referring to. Like, owns what? Owns the Bar Association? Owns the United States Federal Corporation? Owns what? I don't even know exactly what he's getting at. So, yeah, don't know. So, okay, so venue man and woman, that's where we're at. Person. Okay, so person again, yep, USC, subsection 8, is an infant, right? Okay. Husband, wife, or spouse. Couldn't find any verification on this either direction. I did look for them. Nothing I could find in Bouvier's that had any specificity, So I would just, if there's ever a question you can't find it in Bouvier's, always make sure that you look it up. Well, even if you can find it in Bouvier's, always make sure that you look up all definitions within the statutes that they're trying to use against you, because the definitions are always stated within the statutes, acts, ordinances, or codes themselves. And they're usually stated right in the beginning of said whatever. So Always check those first as well to make sure that they don't differentiate from the definitions that you would find in Bouvier's. So, because then they control when it comes to whatever is defined within the statute. Okay. And then again, the people, mankind. Yep, that's fine. All right. Sui juris. This is what I was getting down to. All right. Latin. Of one's own right, one who has all the rights to which a freeman is entitled. Hence the reason I use the word freeman. One who is not under the power of another, as a slave, a minor, and the like. Again, as an infant. Good point. To make a valid contract, one must, in general, be sui juris. True. And this lect law link does not work, so don't even bother clicking on it. But from Bouvier's, we have sui juris, one who has all the rights to which a freeman is entitled. That's important. One who is not under the power of another, as a slave, a minor, and the like. 2. To make a valid contract, a person must, in general, be sui juris. Period. Everyone of full age is presumed to be sui juris. What's the opposite of that? To be an infant. So if the presumption is you're an infant, the presumption is you are not sui juris. Got it? Okay. Also says appearing on one's own behalf, meaning that you are not beholden to or obligated to anyone in or out of government. Okay, I more or less agree with that. Referring to people who present themselves as a living soul in a flesh and blood body, presenting the laws and the facts. Okay, you don't need this level of specificity. You're just one of the people. And you've been found to be living. And you've come of full age. Those things, fine. You don't need the whole living soul thing, the flesh is here and the blood moves, or whatever the hell some ridiculous people say. Use terms that are actually at law, okay? You stick to constitutional terms, you'll be fine. And then on the de facto side, he says pro se represents oneself in person or in persona, meaning mask, as a fiction, serving as one's own attorney, a privilege that can be taken away at any time. And then he's got a court case here, United States versus Doherty. I don't know if I've ever seen that case. And then pro per, short for appropriate persona, meaning proper person. Since person is a fiction, you are telling them you are in your proper mask, not a man by any means. Okay, well, yeah, that's the thing about the represent part, which I think he gets into down here, maybe. If you're representing something, you're not present. So I kind of get that point. The other way that I like to say it, I mean, if you have to say it in court, you're stuck in there. You say to the judge, say, Your Honor, I come before this court as la, 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 whatever the proper terms you want to use. One of the people of the several states of the American Union. I come before this court as having been found to be living. I come before this court as the sole lawful executor of John Henry Doe, or whatever the hell the name is on the constructive trust that the court case is. Whatever. That's how I state it. Instead of worrying about, oh, I'm present, or arguing or trying to prove a negative. Your Honor, I'm not representing myself. Well, the judge is just going to say, what are you representing? So you always have to be careful with that. You specifically have to be careful with it when you're trying to prove a negative. There's no reason to ever do that. You always want to state what you are, not what you're not. Okay. And then to move down here. Oh, okay. I was going to say, did I miss declaration? Okay, here we go. All right. So affirmation, he has on the de jure side. Testify to the facts, written testimony of the facts, written statement of the facts. An affirmation. Okay. That's kind of correct. All right. Declaration. To declare by these presents. And then he has a thing in quotes here, but I have no idea. He has no reference as to where it came from. Anyway, quote, being of sound mind over the age of 21 years. That's not relevant. Doesn't fucking matter if you're over 21. Doesn't matter if you're over 12. Having come of full age means that you can handle your own affairs. It's not a number. And having firsthand knowledge of the facts stated herein, do hereby tell the truth, the whole truth, and nothing but the truth. And herein saith, declare, proclaim, and claim as follows. Okay, that's a little wordy. Not necessarily incorrect, but I wouldn't be that verbose about it. Okay, so a declaration. What really is a declaration? Let's go to Bouvier's. Pleading. A declaration is a specification in a methodical and logical form, most important there is logical, of the circumstances which constitute the plaintiff's cause of action. Right, your cause. Why are you here? Why are you convening a court to take care of this? In real actions, it is most properly called the count. First count, second count, third count. In a personal one, the declaration. So in real actions, it's a count. Huh. I don't think I knew that before. Interesting. All right. The latter, however, is now the general term, being that commonly used when referring to real and personal actions without distinction. Yeah, exactly. So yeah, they just call it a declaration. Okay. And then second definition, the declaration in an action at law, which means common law, answers to the bill in chancery, meaning this is what this side's like, that's what that side's like, which is exactly what I said before. At law, you have a declaration. At chancery or equity, you have a bill, supposedly a true bill, but you don't want to confuse. Okay, you don't want to confuse a true bill in equity that you do yourself with a true bill that comes from a grand jury. Two different things. Okay, but anyway, to continue, the libel of the civilians and the allegation of the ecclesiastical courts. Okay, so they're just stating the different terms in different jurisdictions. So you have a declaration at law, bill in chancery or equity, libel under civil law or Roman civil law, and an allegation of the ecclesiastical courts. At least that's what this says. Which is interesting because when I tried to go look up allegation, I don't know if I found it. I couldn't find allegation anywhere. But at least in the definition here under definition of declaration, the allegation of the ecclesiastical courts. So that certainly suggests that an allegation is ecclesiastical, but I would have preferred to just found the definition of the word, but it wasn't in Bouvier. So anyway. Okay. So next one, affidavit. So he has affidavit on the de facto side, which again, I don't exactly agree with, but let's go down and read what it says. Oh, and by the way, I'm not going to read through all of declaration because it goes on forever. There's all kinds of different declarations. There's 7 different parts of a declaration, which I told you guys before. So it goes through all of the proper parts of a declaration. There's 7 parts in a declaration and 9 parts in a bill in equity. So it lays them all out in here. Not going to go through all of them, but they're there if you guys want them. Okay, affidavit. Practice. An oath or affirmation reduced to writing, sworn or affirmed before some officer who has authority to administer it. It differs from a deposition in this, that the latter, meaning deposition, the opposition party has had an opportunity to cross-examine the witness, whereas an affidavit is taken ex parte. So a deposition is something you do in front of usually a tape recorder. Usually both attorneys are there and people get to cross-examine the other parties. Basically what a deposition is, for the most part, is taking care of these things outside of court in really, really big cases where you have, say, hundreds of witnesses. People tend to take depositions outside of the court, so it doesn't take up a tremendous amount of time in the court. And then definition number 2 for affidavit out of Bouvier's is affidavit to hold to bail is in many cases required before the defendant can be arrested. Okay, so that technically is what should happen in a preliminary hearing, which of course they don't fucking do anymore. But if you look it up in any state statute under the criminal code, particularly under criminal procedure, and this does not deviate from any state, period, because it's a basis of common law, which they can't get out of. So anyway, what it says is that upon arrest, with or without warrant, The accused must be taken directly before the nearest and most accessible magistrate. Now, in some states, it also continues to say that a preliminary hearing must then be had to determine the ability of the court to hold the accused, or something to that sense. Because a preliminary hearing is where, all right, and say it was just you and me that saw some son of a bitch whack a woman over the top of the head with a baseball bat, take her purse, and the guy's like running straight at us, right? So if you and I decide to tackle him and smash his head into the sidewalk, knock him out, tie him up, throw him over our shoulder, and then walk to the nearest and most successful magistrate for a proper evidentiary hearing to prove that he did such, and we say, hey, woman, here's your purse back. Now come with us because you're the witness or another witness. Right? And we get to the judge's front door and we drop the idiot onto his back porch and say, look, we caught this guy stealing this woman's purse. The woman's here. That counts as a preliminary hearing. I don't give a shit if it's on his front porch or back porch. Doesn't matter. The nearest and most accessible magistrate means the guy you can get to the fastest. It does not mean that you take him to jail and let him sit there for several days before a magistrate decides to wander his ass to the courthouse. That's not what that means. Never has been what that means. And the reason why is because the second that you take somebody's liberty, you have to explain why you did that. You don't get to punish them before you have that explanation laid down and recorded in a hearing. That's why they all say that. Now, can you whack him over the head for arrest and bring him to the magistrate? Sure, that's fine. You used reasonable force to arrest. Don't you see cops beating people's heads in all the time to arrest them? Sure. Well, he kept wiggling, Your Honor. I had to knock him out. Fine, whatever. That's lawful as long as you're arresting from a standpoint of, hey, he caused a damage, harm, loss, or injury to someone else. That's fine. Now, am I saying that it's really justified when any of the corporate pigs do it? No, obviously, because they're not actually following common law. They're arresting people based upon statutes, acts, ordinances, and codes, right, which is all on the de facto side over here. But anyway, I was just stating that because that's the way things should go down, okay? All right, so get back on track here. All right, affidavit. So again, this is, okay, affidavit to hold, fine. Indebtedness, show a distinct cause for action. 3, the whole must be clearly and certainly expressed, right? You can't have half-truths. This is where you can get a lot of stuff thrown out because cops write shit so horribly. And then 3, an affidavit of defense is made by a defendant or a person knowing the facts in which must be stated on positive ground of defense on the merits. Hey, that wasn't me. I was over here, whatever. It has been decided that when a writ of summons has been served upon 3 defendants and only one appears, a judgment for want of an affidavit of defense may be rendered against it or against them. Okay, that's about like splitting cases. I don't want to get into that. Okay. Back to the website. Dejure side says, speak the truth. My word is my bond. Cannot swear or make an oath. He's got some Bible passages there. I don't know if that is truly what those say. I've seen people throw Bible passages around a lot, particularly in this field of research. Sometimes they're right, sometimes they're wrong. Sometimes they are wildly incorrect. But I'm not even going to try to go down that road right now. So speak the truth. Your word is your bond. That's fine. There's nothing wrong with that. Doesn't mean it can't be on the de facto side as well. But he says on the de facto side is an oath. Well, no. You can make an oath on a totally de jure aspect. Now, if he's a Christian and he's saying, oh, I can't make an oath because it's against the Bible, well, that's his problem. Doesn't mean it's automatically a part of the de facto side of law. And then de jure side says, I do not accept. He says, I take exception to that. And de facto, he says, I object. Objection, please. No, you can object at law. That's not true. Now, the exception thing, I will read that because I'm very interested in the fact that most people have no idea that after, say, you object in court say the judge overrules you or the magistrate. You can say exceptions. Well, most people don't know what that means, so I'm going to explain it. Or Mr. Bouvier is going to explain it. So exception. Practice. Pleading. This term is used in the civil nearly in the same sense that the word plea has in the common law. In chancery practice, it is the allegation of a party in writing that some pleading or proceeding in a cause is insufficient. Exceptions are dilatory or preemptory, meaning before or after the thing happened. Dilatory exceptions are such as do not tend to defeat the action, but only retard its progress, meaning, hey, you screwed something up here, you have to fix it before we can move forward. Declinatory exceptions have this effect, as well as the exception of discussion opposed by the third possessor or by a surety in a hypothecary action, or the exception taken in order to call in the warrantor. I don't even know what that would be in terms of. To continue, a declinatory exception is a species of dilatory exception which merely declines the jurisdiction of the judge before whom the action is brought. Okay. Preemptory exceptions are those which tend to the dismissal of the action. Some relate to form, meaning you didn't file this correctly. Other arise from the law, meaning the law doesn't apply to me. Those which relate to forms, again, sorry for the misprint here, that shouldn't be an E there, tend to have the cause dismissed owing to some nullities in the proceedings. True. Like, good example of that is a plea and abatement. Okay. Even though I know we're talking about exceptions here. These must be pleaded in limine litis. Preemptory exceptions founded on law are those which, without going into the merits of the cause, show that the plaintiff cannot maintain his action either because he is prescribed or because the cause of action has been destroyed or extinguished. These may be placed any time previous to definitive judgment. Right. So anything regarding these types of pleas or exceptions at all, they all have to be done prior to definitive or final judgment. Can't bring these things up after the fact. Okay, but this one, okay, definition 5 is the one I really kind of wanted to get to or speak about. So 5, the exception is also meant the objection which is made to the decision of a judge in the course of a trial. See Bill of Exceptions. So again, you say something, judge says overruled, right? You say, objection, Your Honor, such and such. Objection, Your Honor, hearsay, whatever. Judge says, overruled. All you have to say after he says overruled is exceptions. That's it. That's all I have to say. And then at the end of the trial in the inferior court, you can then make, again, what's called a bill of exceptions, which is where you basically are creating all these things and saying, hey, all of this stuff, I objected to what the judge did in the course of trial. Okay. Now, why do you do that? Why does it end up being a bill of exceptions? Well, it's because every single time the judge does something that's incorrect, he's basically trespassing upon your substantive rights, which is an injury, which is why he owes you damages, which is why you write up a bill for his ass. Anyway, that's that. All right. And I think the last one I have here under Bouvier's is lawyer. Lawyer is a counselor or one learned in the law. Okay. So that's it. All right. So that's what I had for all of the definitions. Okay. Now, again, the definitions will be in the show notes in the mega file. Okay. All right. Between counsel and attorney here. All right. So counselor in law, fine. Lawyer is one who knows the law, which is what we just read. No license is required. No registration required. No bar certificate required. Just needs to know the law. True. The law is simple. Do not offend anyone. Honor all contracts. True. Again, as I usually say, do not cause any damage, harm, loss, or injury to anyone or their property, and uphold all contracts. And of course, one has to recognize God's law. Well, that depends on who your God is, I suppose, but some refer to it as nature's law or natural law. That's technically how it is referred when you're dealing at common law. You just refer to it as natural law or common law, such as gravity, air to breathe, so on and so forth. Another basic choice one may live by is the golden rule. Again, same thing. And others acknowledge and abide by the 10 commandments. True, that's fine if you're a Christian. These laws are simple, easy to understand, not hard to know, and do not change. Also true. There are no codes. Anyone can be a lawyer. Yes. Again, if you want to study law and understand what the law is, as I have, or as you have, being a part of the vocational science of freedom, yes, you're considered a lawyer. Now, what's an attorney? An attorney is an esquire, British nobility, a title meaning shield bearer. Attorney at law, the defense attorney, prosecutor, and the so-called judge are also attorneys doing business in the corporate administrative courts, tribunals, of the U.S. as agents of the Crown of England. Yeah, okay. I mean, again, I'd like to find a lot of this connection where anybody that's an esquire, okay, there's no question about that, because an esquire is one title under a knight of the English gentry. So that's absolutely correct. But that the attorneys are all automatically agents of the crown, I've still never found evidence of that. Again, I'm not disputing it outright. Makes sense in theory. I just would really like to see some proof of that. So, next part, attorneys swear an oath to uphold the Bar Association. Well, yes, but they also swear to uphold the court. So their first oath is to the court. So if that court happens to be a corporation, well, then they're swearing oath to a corporation. Sorry. But their first oath is always to the court, not to their client. So anyway, next one under that, the Bar Association is registered with the Internal Revenue Service as a 501c3 organization, like a religious tax exempt organization. Sure. Again, I'd like to see proof of that, or the proof, just so we can share it with everybody. Some people believe that the first letter of the bar stands for British accreditation, or British accredited registry. This could be a myth, although the term bar may also have originated in London, having to do with an obstruction that denies or allows entrance, such as raising the bar, being a bridge or a gate. The bar in the U.S. was first organized in Mississippi in 1825. Never knew that before. I'd like to see expanded evidence on that one and exactly what was the organization. And then from Black's Law Dictionary, 4th edition, we have the integrated bar movement, meaning the condition precedent to the right to practice law, was initiated in the U.S. in 1914 by the American Jurisprudence Society. Okay. Well, 1825 and 1814 are pretty far apart. Almost exactly 100 years. So, yeah. All right. And then I don't know why a state of California in here. I don't know what this is. Let's see if this works. Attorney Oath of Office and Bar Association, Section 6067 of the California Business and Professionals Code requires that every attorney must file an oath of office with the Secretary of State, stating that upon admission shall take oath to support the Constitution of the United States and the Constitution of the State of California, and to faithfully discharge the duties of an attorney at law to the best of one's knowledge and ability. A certificate of the oath shall be endorsed. A certificate of the oath shall be endorsed upon licensure. Interesting. Okay. The California Bar Association was incorporated in 1901. Corporation number so on and so forth. According to the incorporation papers, the corporation would exist for a period of 50 years. In 1951, the corporation ceased to exist. Funny. The California State Bar Association now does not officially exist in the state of California. It now operates as a chapter of the national organization. Interesting. Okay, so this looks like he has some more fun information about the bar. Fun. Continue on the de facto side here. When only attorneys can understand the code, statutes, and regulations, so-called laws, then only attorneys should be required to obey them. Oh, wouldn't that be nice? That's Jack Slevkov, 2002. And then, should I have an attorney? No. Because every time that you hire an attorney, you're automatically considered a ward of the court, which I'm pretty sure this is going to say here. An attorney's first duty is to whom or to what? If we consult the latest Corpus Juris Secundum, Volume 7, Section 4, we will find that an attorney's first duty is to the courts and the public, not the client. What did I just get done saying? Attorney and client, his first duty is to the courts and the public, not to the client. And whenever the duties to his client conflict with those he owes as an officer of the court and in the administration of justice, the former must yield to the latter. And then attorney-client privilege. What is the legal relationship between attorney and client? Yeah, they're acting as the administrators of abandoned infant estates. That's what they're doing. A client is one who applies to a lawyer or counselor for advice and direction in a question of law or commits his cause to his management. In prosecuting a claim or defending against a suit in a court of justice, one who retains the attorney is responsible to him for his fees and to whom the attorney is responsible for the management of the suit. One who communicates facts to an attorney expecting professional advice. Clients are also called wards of the court in regard to their relationship with their attorneys. You're a ward. Ward of court. What is a ward of court? According to a court case, wards of court are infants and persons of unsound mind. Starting to see everything come full circle now, finally, are you? Yeah. Just administering abandoned infant estates, people. That's all they're doing. Okay. On to... All right, so he's got Supreme Court of the United States and then United States Supreme Court, meaning the de facto and the de jure side, meaning one's a corporation and one is the legitimate, proper Supreme Court. And next one, District Court, United States of America, where implemented for territories that were not states. Oh, yeah, that's true. Yeah, because the district courts were set up for that. And they were supposed to be territorial courts, yeah. And the United States District Court is not the same thing. True. Lawyer or counsel, we kind of already covered that already. All right, prosecutor. In the early days of our republic, prosecutor was simply anyone who voluntarily went before the grand jury with a complaint. Okay, interesting. That's United States versus Stanford, federal case, so on and so forth, 1806. You can also prosecute your own court of record case, meaning, because a tort is definitely a trespass, and a trespass is certainly an aspect of a criminal. It's a criminal thing. So it's not the only way you could do it, but that's just one way that you can call yourself prosecutors by taking it before the grand jury. Okay. So prosecutor on the de facto side, a government official who conducts criminal prosecutions on behalf of the corporate state, an attorney who works for the local state or federal government to bring and litigate so-called criminal cases. At the local level, the prosecutor will usually be the county district attorney's office. In some cases, the prosecutor may be from the city attorney's office. The prosecutor reviews evidence to determine if a complaint may be filed. Fun. And counsel to help the accused or lawyer who knows and studies the law. Defense attorney, right? Kind of already covered that. Dejure must have a damaged party. De facto compels performance. No damaged party is necessary. Okay. Yes, that's more or less true. But it's not that there is never a damaged party on the de facto side, meaning aspects and equity can still actually have a damaged party. But the corporate state just can't be one, really. And then and on the de jure side, maintains rights, freedoms, and liberties of the people. De facto, no rights except civil rights. That would be Roman civil law rights. And privileges that can be taken away at any time, restricts freedoms and liberties. True. De jure, unalienable rights, fundamental rights, substantial rights, also substantive rights, and other rights of living souls are all protected by the law and protected by the organic constitution and its amendments. True, as long as you've rebutted all the presumptions and you are not a citizen of the United States, you've come of full age, you've been found to be living, and you're a member of the posterity, and you've claimed back your state, because then you have title. De facto, U.S. citizens are at the mercy of government and the administrative courts and tribunals, certainly if they're 14th Amendment slaves. Servants, subject bond masters can not sue the master, corporate government, unless allowed to. True. First 10 articles of the amendment to the Constitution are sometimes referred to as the Bill of Rights, which is incorrect. They are not a bill, but are simply amendments. Also not true. The Bill of Rights has its own preamble, and it's its own document, Not that anybody ever reads the preamble of the Bill of Rights, but there is one there. And then he says, de facto, the actual Bill of Rights was a declaration in 1689 by King William and Mary to their loyal subjects of the British Crown. Meh. Was that ever really legitimate either? Probably not. Or did they even uphold it? Definitely not. On the de jure side, due process is required. De facto side, due process is optional. Sometimes Gestapo-like tactics without reservation. True. De jure, innocent until proven guilty. No bill of attainder, no ex post facto law shall be passed. And ex post facto law means you pass a law today and then you go round up everybody and arrest them for something they did yesterday that wasn't unlawful. So that's an ex post facto law. And then de facto side, guilty until proven not guilty, especially when faced with issues relating to the corporate government, its agents, or its highwaymen. Well, true, because it's usually always contractual anyway. The so-called judge will ask if one is guilty or not guilty. Always claim to be innocent. That's a good point. That's also something you should do if you're stuck in an inferior court. I always say, I do not plead to courts of contract, Your Honor. I am innocent. This side, jurors judge the law as well as the facts. Well, if you're in a court of record and if you're demanding a general verdict, yes. Jurors are the last bastion of hope to free one from tyrannical or unjust laws imposed by the government. Yes, as is a 25-member grand jury of the peerage, which is even more important. Jury nullification occurs when a jury returns a verdict of not guilty despite the common belief that the defendant is guilty of the violation charged. The jury, in effect, nullifies the law that it believes is immoral, unconstitutional, or is wrongly applied to the defendant, whose fate it is charged with deciding. Traditionally, jurors are free to disregard the judge if they feel he is part of the system of oppression. Jury nullification is an essential protection for citizens against governmental tyranny, and that's John Tiffany, AmericanFreePress.net. Well, that's all well and good as long as you're in a court of record. But there is no jury nullification in the inferior court system because you got a bunch of infants playing in a sandbox throwing cat shit at each other. It doesn't mean anything. So they don't have the capacity to nullify the statutes. So, all right. So then de facto side, the judge instructs the jurors to try only the facts, not the code, statute, etc. True. The judge usually gives the statute, regulation, code, rule, etc. that will most likely convict the defendant. Well, that's really the prosecution's job, but okay. If there's any dispute with the so-called law, the judge will declare, I say what the law is. Well, that's true. They usually tend to do that, especially when they're pulling up their admiralty side of things. If there is any more dispute with the law, the judge will say, I will hold you in contempt if you continue in this manner. Haha. Well, that's why you want to be a plaintiff in a court of record and sue the jurisdiction away from the inferior court. Crime. This is on the de jure side. A crime is an offense against a public law. This word in its most general signification comprehends all offenses, but in its limited sense, it is confined to felony. Okay. 2, the term misdemeanor includes every offense inferior to felony, but punishable by indictment or by particular prescribed proceedings. 3, the term offense also may be considered as having the same meaning, but is usually, by itself, understood to be a crime not indictable but punishable summarily or by the forfeiture of a penalty. In other words, pay me. 4, crimes are defined and punished by statutes and by the common law. Most common law offenses are as well known and as precisely ascertained as those which are defined by statutes, yet from the difficulty of exactly defining and describing every act which ought to be punished, the vital and preserving principle has been adopted, that all immoral acts which tend to the prejudice of the community are punishable by courts of justice. Yeah, that's a good way to put that. From Bouvier's Law Dictionary. All right, that was de jure. Now de facto, all crimes are considered commercial crimes. Any of the following types of crimes, federal or state: offenses against the revenue laws, burglary, counterfeiting, forgery, kidnapping, larceny, robbery, illegal sale or possession of deadly weapons, prostitution, including soliciting, procuring, pandering, white slaving, keeping house of ill fame, and like offenses, all under prostitution, extortion, swindling, and confidence games, and attempting to commit, conspiring to commit, or compounding any of the foregoing crimes. Addiction to narcotic drugs and use of marijuana will be treated as if such were a commercial crime. That is 27 Code of Federal Regulations, Section 72.11. Yeah. All crimes are commercial on the de facto side. And why is that? It's because they're charging you for the use of your own body that you don't possess because you don't have title to it, because you never claimed it back, because you've been abandoned. Right? They're saying, hey, you got to pay us for using that thing you don't own because someday somebody might show up and claim it back. Yeah. Poor people have access to the courts the same sense that Christians had access to the lions. Haha. Judge Earl Johnson Jr. And then, quote, there simply is too much law, government, to even function. We cannot get out of our own way. We have tied ourselves into knots. When we are supposed to have a limited government, and the purpose of the Constitution was to tie government down to the express powers, given it, I should say, vested it, there simply is nothing left the government does not touch, have its hands on, and has made a mess of. True. More law, more government will not save us. They are the problem. Close quote. From an article written in 2006 by attorney Gary Zierman titled South Dakota Government Acted in Concert Against the People. Well, every once in a while an attorney says something correct. Last, most courts have become the collection agency of the corporate government system for the debt created by said system to be paid in part by the people who come before the so-called court. Right, again, get charged with what you're doing. Because again, all crimes are commercial. Lawful determination on the Dejure side. So the people's one Supreme Court is the county court of record. Yeah, true. The highest court of the land. Once it rules, United States Supreme Courts, federal or state, cannot question the ruling. Read the 7th Amendment. True. The state and federal courts are inferior tribunals to we the people's one Supreme Court. I don't keep calling it Supreme Court. They're superior courts. Superior courts of record. That's the proper term. So the one superior court of record exists wherever the people convene it. The people have agreed to convene it at the county seat, and the county judge is elected by the people as the administrator of their superior court of record. He makes no judicial ruling. He is only there to keep the court open to see that it runs in an orderly fashion to enforce the judgments of the court of the people. When the jury is called and has been sworn from among the people, there are 12 justices sitting as one supreme tribunal of the superior court of record for the people of that county. Close quote. That's how that should have read. Thomas Jefferson, worried about the courts would overstep their authority and instead of interpreting law would begin making law. Well, that happened a long time ago. And oligarchy, the rule of few over many. True. The very first Supreme Court Justice, John Jay, said Americans should select and prefer Christians as their rulers. Well, I don't particularly care for a ruler at all. Thank you, Mr. J. Okay, and then on the de facto side, legal determination. So over here we have lawful determination. Here we have legal determination. There is no lawyer or judge that can or will go against this colorable system. True. Under this system, the judge makes legal determinations which is in accord with the creditors of the country. No lawyer will demand a judicial determination. Legal determinations are not appealable, as are judicial determinations. Legal determinations are anything the judge says they are under their colorable public policy laws. However, judicial determinations are in accordance with public law and are subject to constitutional constraints. Some of that's right, some of that's wrong. So anyway, quote, since Erie Railroad versus Tompkins decision in 1938, the courts have been operating under public policy in the interest of the quote unquote nation's creditors instead of public law in accord with the Constitution. That's more or less true. We covered that, everything that goes along with this, in the reading of the USA, the Republic that no one lives in, which is a fairly long set of classes, but extremely important. Again, they lay out to much more detail what this article is trying to do, but honestly not doing it very well. So again, if you want the real breakdown of that, particularly during Erie Railroad decision, 1933, and everything else, again, watch USA, the Republic is the house that no one lives in. And again, you can find that in the playlists on YouTube, on Rumble, and on Odyssey. All right, to continue. On the de facto side, the judges are not allowed to consider any case law prior to 1938. Surprise, surprise. But there is one case, Clearfield Trust, 1943. All courts are administrative tribunals operating under a colorable admiralty jurisdiction called statutory jurisdiction, and all judges are administrators. All lawyers are officers of the colorable courts. Okay. I don't know if I have Clearfield Trust case. Should definitely find that on Justinia and save that one. Because that's one hell of a holding, if that is indeed what that holding said, which I seriously doubt it read like that, but it probably read something akin to that. But that'd be a good one to look up and keep. Because if you can prove that everything is commercial and say, okay, fine, great. Where's the contract? Right? Produce the contract upon which you rely to make the assertion. That's the important thing. Wow, you did find it that fast. Thank you, Spectre. Clearfield Trust Company, U.S. United States, primary holding. Okay, that's what I want. All right. Primary holding. A federal court can make a common law rule regarding federal negotiable instruments since they are controlled by federal law. Okay. That's not exactly what this thing said, no, is it? But anyway, this is saying it in the negative. This is saying it in the positive. So, all right, let's just read that again, because this is from Justinia. A federal court can make a common law rule regarding federal negotiable instruments since they are controlled by federal law. Well, isn't that just all special? You guys made your little monopoly, buddy, and now you just want to play with it. Okay, so what? Great. All right. Anyway, facts. This is again reading from Justinia. Facts. A check issued by the federal government was intercepted in the mail before it reached the intended recipient, J.C. Penney Company. Endorsed it after it was cashed, thereby the person who intercepted it and forged the endorsement, Clearfield Trust Company. Also endorsed the check with a guarantee of all prior endorsements and collected the appropriate sum from the Federal Reserve. Here we get into the money printing, everyone. 8 months after it discovered the forgery, the federal government demanded Clearfield to pay on the guarantee. It brought an action against Clearfield when it refused to comply, but the trial court ruled that it could no longer bring the claim because it had delayed so long. The appellate court disagreed and reinstated the action. Okay, interesting. Now, here, this whole entire time, I thought this was actually dealing with Federal Reserve notes, but it's not. It's just dealing with a check. Now, in a sense, are Federal Reserve notes still, in a sense, negotiable instruments? Yeah, kind of, sort of. But this is specifically dealing with a forged check from the federal government. So, a little bit different, but okay. Okay, so does this match up at all then? All right, so he says, judges are not allowed to consider any case prior. Okay. All courts are administrative tribunals operating under callable admiralty jurisdiction called statutory jurisdiction. All judges are administrators and lawyers are officers of colorable courts. Okay, that's not what the holding said. Unless it's buried in here. Okay, unless what he just read from is actually dicta and not the holding. And I hate it when people do that. Okay, and if anybody doesn't know, dicta is just the judges talking, okay? It doesn't actually mean anything. It's not the actual holding of the case. Dicta is just the judges basically laying out in their opinion how they came to their opinion. That's what dicta is. And you should never use it as a court holding. So anyway, we'd have to cross, and I don't even bother to do it now because we're almost into 2 hours. So if this matches up anywhere in here, it would have to match up in the dicta if it did at all. So anyway, back to the last bit here. All right, so on the de jure side, everyone is responsible for their actions and words spoken. It does not matter what position or title one has in life. De facto, the United States Supreme Court gave full immunity against both civil and criminal prosecutions for perjury to judges, attorneys, court reporters, stenographers, law enforcement officers, and expert witnesses who testify for the state. See a brief on judicial immunity. Okay, I see, because that is a pretty broad statement. Okay, my name is William Michael Windsor. Most people know me as Bill Windsor. I felt all judges. Okay, this is just some guy's opinion. This is not a fact of the Supreme Court. See, this is the problem when people do this. They just say things as though they're automatic, and then they go and they base it off of somebody's opinion online. That's not a court case. Sorry. Now, again, I don't have any problem with theory. I don't have any problem with people talking about theory. What I have a fucking problem with is people saying that something is absolutely true when they don't have the proof to prove it. Or stating that it's automatic. This is how it is. Really? Okay, then show me some evidence. Don't just state it as it's, as it's God. Give some evidence. Court case? Fine. Supreme Court? Fine. A case that had all the merits in it, but it didn't go the right direction and clearly the judge was corrupt? Okay, fine. But prove that. Don't just put up some stupid website of somebody else's opinion. Then you're just trying to browbeat somebody and it doesn't get you anywhere. It doesn't prove anything. So anyway, I think I'll stop here for the night. So we're going to stop at prisons for incarceration, prisons for profit. I'm just going to go through and check chat anywhere else. Looks like there were some few things on Rumble. Somebody said you're wrong on the definition of real and personal. Well, I read it, so I'm not wrong. Real property is an artificial or natural thing that the state government agency holds an interest. No, that's not true. Again, all right. So anyway, not going to read the rest of that. Again, opinion. What's this, Spectre? Extra color of law. Okay. Clearfield Trust Company. Hey, Nerdy. Good to see you. Was this both based on Clearfield Trust? And by the way, sorry, Spectre, let me unmute everybody in chat so you can talk if you guys want to. So what was this, the second part of Clearfield, or was this the same thing? Oh, just a different. Oh, this is from Cornell. Okay. Okay, this gives at least the background. Our check was drawn on the Treasury of the United States to the Federal Reserve, Philadelphia, ordered. Okay. Oh, it was over $20. That's why I guess they're stating it's in common law. No. All right. Pay to the order of the Federal Reserve Bank. Okay. Philadelphia. Okay. Executed an affidavit alleging the endorsement on his name and check was a forgery. Right. They didn't find out until 8 months later. Right. We agree with the Court of Appeals. The right and duties of the United States on commercial paper, which it issues, are governed by federal rather than local law. Okay. Yeah. Because they created it. Fine. When the United States distributes its funds and pays debts, it is exercising a constitutional function or power. Well, not if it's Federal Reserve notes, but whatever. This check is issued for service performed under Emergency Relief Act. The authority to issue check has origin in the Constitution and statute of the United States and is in no way dependent upon the laws of Pennsylvania and any other state. Well, that's true. Okay. I'm still not seeing. I'm still not even seeing the dicta that he has on the de facto side in the court case. Like, okay, Tyson Swift. Yeah. Anyway, I'm still not seeing it. Anyway, so I think it's just the guy's opinion. Which, again, I don't mind people coming up with theory, but don't ever state your theory as if it were God, as if it were fact, as if it were absolute. No matter how much you want to believe it or how hurt your feelings are going to be if I tell you that it's not true, or even that I demand that you prove it to be true. Because facts don't give a fuck about your feelings. Sorry. Grow up. And then if there's anything else that anybody had a question about, or not. The chat is open and you guys are unmuted in Mega if you had any questions or not. I know it's been a long 2 hours, so I understand if everybody wants to just be done. So if there's nothing else and nothing else from Rumble hanging out, then we'll call it a night here. And I'd like to thank everyone for coming. I hope you guys learned something. I also want you guys to make sure that you download everything that's in the mega file for this class. There's a lot of other reading that goes along, not just a complete copy of USA versus US in a Word file, Word doc, but also the vocabulary sheet and the Vocational Science of Freedom Timeline doc. So make sure that you download those and take a look at them, read them up, and pass it on, because the only way that we're ever going to get out of this global Luciferian mess is if we first learn what they've done, and then we learn how to undo it. And the only way that we can do that is together. Because everything that I know did not just simply come from just my studying. I've had a lot of good mentors, of which I got a lot of this information from. So do someone a favor who's younger than you are. Become a mentor to them. Start to teach them law. Start to teach them civics. Start to teach them the fact that they are sovereign and that they need to come of full age and handle their own affairs so that they don't get handled by an attorney. Okay. So with that, I bid all of you the rest of this wonderful weekend to be happy and joyous. And I'll see all of the Vocational Science of Freedom members on this coming Wednesday. And again, if anybody wants to join the Vocational Science of Freedom and join our Wednesday night roundtables, you are completely welcome to do so. It is completely free. Just go to vocationalscienceoffreedom.org and download the welcome package and come on into class. Okay. All right. So till next Wednesday, stay safe and stay sovereign.